Hello everyone, welcome back to our channel Legal Nexus. In today's session, we'll be discussing a very significant concept under the Indian Contract Act, Discharge of Surets Liability. A surety is the person who gives a guarantee for the performance or repayment by the principal debtor. However, the surety's liability is not absolute. The law provides various circumstances under which a surety can be discharged from responsibility. Understanding these situations is very important for law students as well as for anyone dealing with contracts and guarantees. Let's explore the different modes and legal provisions through which surety's liability can come to an end. Section 132, 139 of the Indian Contract Act 1872 lays down the provision relating to discharge of surety. Discharge of surety means termination of surety's liability. Surety is said to be discharged when his liability comes to an end. Following are the different modes by which surety is discharged from the liability: revocation of liability, by death, and by novation. The surety can also revoke his liability in variance in the terms of contract, discharge or release of principal debtor when creditor compounds with, gives time to, or agrees not to sue the principal debtor by creditor's act or omission, impairing surety's eventual remedy by loss of the surety by the creditor and by invalidation of the contract. Now let's learn these points detailedly. By revocation, section 113. In continuing guarantee, the surety can revoke his liability as to the future transaction by gives a notice to the creditor, but he cannot revoke in respect of a specific guarantee or in respect of the transaction already entered into. For example, A executed a guarantee to B and gives a loan rupees 10,000 to C. A can revoke the guarantee to be discharged from the liability before the loan is given by B. If the loan has already been received by C, A cannot revoke the guarantee. By death, section 131. Section 131 speaks about the revocation of continuing guarantee by surety's death. It runs as follows. The death of surety operates in absence of any contract to the contrary, as a revocation of continuing guarantee so far as regards future transactions. In other words, death of surety extinguishes the liability and does not extend to the legal representative unless there is an agreement to the effect. By novation, section 62. Novation means substitution of a new contract of guarantee in the place of an old or existing contract of guarantee. The novation may be between the same parties or different parties under same terms or different terms and conditions. The surety is liable under the terms of old contract. When the old contract by novation gets discharged, the surety also gets discharged from the liability. By variance in terms of contract, section 133 provide for the discharge of surety by variance in terms of contract. It runs as follows. Any variance made without the surety's consent in the terms of the contract between the principal debtor and the creditor discharges the surety as to transactions subsequent to the variance. Pratap Singh versus Keshavalal. In this case, X agrees to give a loan to Y on the security of 4 properties. A gave guarantee. Actually, X gave a loan of smaller amount on the security of 3 properties. As there was a change in the terms of the original contract, the guarantor was discharged from the contract or liability. Release or discharge of principal debtor. Section 134 provides for discharge of surety by release or discharge of principal debtor. It runs as follows. The surety is discharged by any contract between the creditor and the principal debtor by which the principal debtor is released, or by any act or omission of the creditor, the legal consequences of which is the discharge of the principal debtor. When creditor compounds with, gives time to, or agrees not to sue the principal debtor, section 135 mentions further circumstances when a contract between the creditor and the principal debtor can result in the discharge of the surety. It runs as follows. a contract between the creditor and principal debtor by which the creditor makes a composition with or promises to give time to or not to sue the principal debtor discharge the surety unless the surety assessed to such contract. According to this section, a contract between the creditor and the principal debtor discharges the surety in the following three circumstances. When the creditor makes the composition with the principal debtor, when the creditor promises to give time to the principal debtor, when the creditor promises not to sue the principal debtor, it may be noted that in the above stated circumstances, the surety is discharged if the creditor and the principal debtor make such contract without the consent of the surety. If such a contract is made with the consent of the surety, he would not be discharged. Discharge of surety by creditors act or omission impairing surety's eventual remedy. Section 139. Section 139 of the Indian Contract Act 1872 run as follows. If the creditor does any act which is inconsistent with the right of the surety or omits to do any act which his duty to the surety requires him to do, and the eventual remedy of the surety himself against the principal debtor is thereby impaired, the surety is discharged by loss of the security by the creditor. Section 141 deals with surety's right to benefit of creditor's securities. It runs as follows. A surety is entitled to the benefits of every security which the creditor has against the principal debtor at the time when the contract of suretyship is entered into, whether the surety knows of the existence of such security or not, and if the creditor loses or without the consent of the surety parts with such security, the surety is discharged to the extent of the value of the security. By invalidation of the contract, according to section 142, guarantee obtained by misrepresentation is invalid. It read as under. Any guarantee which has been obtained by means of misrepresentation made by the creditor or with his knowledge and assent concerning a material part of the transaction is invalid. When the contract is declared invalid, subsequently the surety is discharged from the liability. Surety's rights. Section 142-147 of the Indian Contract Act confer on sureties certain rights which may be explained under the following heads. Rights of surety as against the creditor, rights of surety as against the principal debtor, and rights of surety as against co-sureties. Rights to security with the creditor. Section 141 provide for surety's right to the benefit of creditor's securities. It runs as follows. A surety is entitled to the benefits of every security which the creditor has against the principal debtor at the time when the contract of suretyship is entered into, whether the surety knows of the existence of such security or not, and if the creditor loses or without the consent of the surety parts with such security, the surety is discharged to the extent of the value of the security. To better understand, we can go through the case State of MP versus Kaluram. In this case, the surety was discharged by the loss of security by the creditor. The facts of the case are as follows. The respondent Kaluram was surety for the payment of felled trees which were sold by the appellant to one Jagatram. The buyer of the trees was to make the payment in 4 installments. He paid only 1 installment and then defaulted. The appellant had a right under the contract to prevent the purchaser from removing the trees when he was in default. The appellant failed to do. The court held that the appellant, by allowing the buyer to take away the trees, had allowed the security to be lost, and the surety was therefore discharged to the extent. Right to request. Surety has the right to request the creditor to elect or choose the principal debtor to sue before he is called upon to pay debt. Right against the principal debtor, right to subrogation. Section 140 confer on surety the right of subrogation. The term subrogation literally means transfer of right from one person to another in a contract of guarantee. The right of charge over the security is vested in the creditor. According to Section 140, where the surety has cleared or paid the debt in full against a fault by the principal debtor, all the rights which the creditor has against the principal debtor get transferred to the surety. In other words, the surety enter into the shoes of creditor and can sue the principal debtor for recovery of the payment made by him. Section 140, which confer on surety the right of subrogation, run as follows: where guaranteed debt has become due or default of principal debtor to perform a guaranteed duty has taken place, the surety upon payment or performance of all that he is liable for is invested with all rights which the creditor has against the principal debtor, right of indemnity. In a contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety from losses caused to him as a result of contract. In other words, the surety can recover from the principal debtor whatever sum he might have rightfully paid under the guarantee. Rights of surety against co-sureties. In a contract of guarantee, if there are two or more sureties, they are called co-sureties. The liability of co-surety is joint and several. The creditor may sue one or all. If only one surety is sued and he alone has paid the debt, he may ask or demand the co-sureties to contribute proportionally. Such right of the surety to demand contribution from the co-surety is called the right of contribution. Section 146 of the Indian Contract Act 1872 confer on surety the right of contribution. In other words, Section 146 says that the co-sureties are liable equally. It runs as follows: where two or more persons are co-sureties for the same debt or duty, either jointly or severally, and whether under the same or different contracts, and whether with or without the knowledge of each other, the co-sureties, in the absence of any contract of the contrary, are liable as between themselves to pay each an equal share of whole debt or of that part of it which remains unpaid by the principal debtor. In conclusion, the discharge of surety liability is an important legal safeguard that ensures the surety is not held bound in unfair or altered circumstance, whether through contact of the creditor, variance in contract terms, release of the principal debtor, or operation of law. The surety can be freed from the responsibility in several ways. By knowing these provisions, we can better understand how the law maintains a fair balance between the creditor, the debtor, and surety. Thank you for watching this video. If you like this video, please don't forget to like, share, and subscribe.